Hi, good afternoon. On behalf of the Board of Bar Commissioners and the State Bar of New Mexico, I'd like to welcome all of you to Albuquerque. Hope you do have some opportunity after the conference to get out there and, explore what our city has to offer, and maybe some of you are here for the weekend. I do have the privilege today of introducing our luncheon speaker, who is Chief Justice Charles Daniels. He asked me to keep it short, so I'm going to keep it very to the point. In his humble opinion, as he said, just say, I practiced law for almost 40 years, and I now have a government job. I think he deserves a little more introduction than that. But I'm not going to go through the degrees. I'll just tell you the fun stuff about him. He just started his second term as Chief Justice. They are selected. He's selected by his peers, by the other justices on the Supreme Court. He and his wife, Attorney Randy McGinn, who's an attorney here in Albuquerque as well, have 4 grown daughters, have 4 grandsons, 3 granddaughters. For fun, he likes to play the bass guitar in a blues rock band, which is very good. For those of you who might be here next week, they're playing at Scala, which is a restaurant in Nob Hill. And he's also a semi-professional race car driver, and he has a race in Deming this weekend. So please help me welcome Chief Justice Charles Daniels.
Yes, that was short enough, thanks. Let me get away from this piece of wood here. I submitted a paper. I don't know if that's been distributed on paper or online or whatever. I'm not going to repeat everything that's in the paper. It's entitled Pretrial Injustice, the Need for Reform. And with this crowd, I don't think I have to spend very much time talking about the need for reform in our pretrial justice system in the United States. I think those who are intensely interested in criminal justice issues, as are the members of this section of the American Bar Association, already know that however rational our justice system may be in litigating guilt or innocence at trial, all the rights we protect to confrontation, to jury trial right, to presumption of innocence, proof beyond a reasonable doubt, all those kinds of rational procedures that we have in our adjudication system are missing, by and large, in the pretrial justice system, which is anything but just in most jurisdictions, including historically in New Mexico. So I'm not going to spend a lot of time talking about the need for reform the way I would to a lay audience, and I won't spend a lot of time repeating some of the details in that paper, but if you're interested, there are a lot of references in there. There's a lot of historical detail that may be of interest to you. What I want to share with you is the journey that we're taking here in New Mexico. For those of you who are taking a similar journey in your jurisdictions around the country, or who may be thinking about it, because there is a reform movement underway not only in my state, but nationally. I just talked to one of your members here from Connecticut this morning about some efforts that are underway there. There are some efforts underway in Texas. There are efforts in other jurisdictions. I've been in touch with some of my counterparts on courts around the country. And I won't say it's yet a tidal wave, but hopefully one is coming in this area. It's one that's long overdue. And I probably ought to start out with a confession and an admission that I was once wrong. Not just one time, but on this issue. As I get older, I find more and more things that I was once wrong about. When I was a young lawyer, I wasn't born old. I was once a young lawyer. Over 45 years ago, I started out defending criminal cases in the courts of the District of Columbia, arguing for release on bail and doing all the things you do as a criminal defense lawyer. And I helped a Georgetown law professor prepare testimony for a congressional hearing to oppose a new concept that was being offered in the D.C. crime bill, which was to provide a system of preventive detention, denial of any release on bail for those who posed an undue danger or flight risk. And this criminal law professor from Georgetown was outraged at this assault on the presumption of innocence and had me as a young lawyer working with him to help prepare testimony. We were unsuccessful. The bill passed, the D.C. crime bill, and a few years later, the federal government adopted this detention system for the United States courts. A couple of years after we prepared that testimony, I found myself being asked to work with the New Mexico Supreme Court Rules Committee, Criminal Rules Committee. Our court in this state supervises the promulgation of procedural rules, rules of evidence, rules of procedure, rather than the legislature. And I was a young law professor then at UNM Law School, and I was asked to work with that committee to promulgate new rules of procedure, including significantly pretrial release rules. There had been a wave of reform primarily in the 60s, resulting from experiments with the Vera Institute in New York City on release on recognizance and other non-financial conditions that had led to the adoption of the Federal Bail Reform Act of 1966 that put an emphasis on release on non-financial conditions and using money as a last resort, at least on paper. And we adopted essentially the Federal Bail Reform Act through court rules in New Mexico that provided a hierarchy of release conditions that looked at individual risk and would not require any money to be posted unless it was a last resort. And for a while, things changed in this state. And then over the years, since 1972, when we adopted those rules, we saw more and more bail bonding offices crop up like toadstools after a rain around our courts. You can go down to our trial courts at 4th and Lomas, where we have the district court and the metropolitan court and the federal court all within a block of each other. And all around those courts, there are these little bondsman's offices with the cute slogans, "You ring, we spring." "We get you out of jail if it takes 10 years. And there's one with a little, real nasty-looking little thug with some kind of spiky hair, and the slogan there is, "'Cause jail sucks." It also has on that sign, which you can see from the courtrooms of the Metropolitan Court and the District Court, 0% down on approved credit. So that if you're charged with armed robbery, for example, and you don't have any money on you, you can say, "Let me get one of those credit deals and give me a day or two. I can come up with that." The result has been that in New Mexico, like many jurisdictions around the country, we've been overtaken by a money for freedom system, fueled largely by a commercial system that is a growth around our justice system. Now, the commercial bonding industry will tell you that they're a benign growth, and they do good things. There are others around the country who think the commercial bonding system is a malignant growth. That's the belief in most of the civilized country in the world, because only the United States and the Philippines have a commercial money for freedom system. The origins of that are interesting. I'll tell you how I came about to really focus on it and learn them. For the first 6 years of my 8 years on the Supreme Court so far, we'd never heard of bail appeal in our court. We dealt with convictions and sometimes extraordinary writs, other things. And it was a couple of years ago that an angry young public defender brought an appeal from a $250,000 bail set in a second-degree murder case. The defendant had been in jail about 16 months awaiting trial. There had been a couple of bail hearings, and there had been evidence presented. This public defender fought and presented all kinds of evidence from pretrial services, psychologists, others, and made a showing that this defendant was neither dangerous nor a flight risk. The DA didn't have anything in opposition on those issues, but said simply, "Judge, this is a murder case. This is a serious case, so it should be a high amount of bond." And the judge made specific findings of fact that the defendant was not a flight risk, the defendant was not a danger to the community, but in light of the seriousness of the charges, a $250,000 bail would be set. And so that public defender brought it up to our court. And it was the first case that we had briefed and argued before us on the issue of bail. And it really focused our attention. We started looking at this, and I knew from those bail rules that I'd worked on when I was a young law professor that you weren't supposed to impose money bail requirements unless someone was a serious flight risk. And so we decided we better start looking into what we're doing in this state. In addition to ruling on that case and ruling that there had been no showing of a need for a monetary bond and reversing that bail decision, we created a task force, broad-based task force, chaired by a former dean of the law school, criminal law professor, and with representatives from the District Attorneys Association, from the Criminal Defense Lawyers Association, from the public defenders, trial judges at various levels, detention center officials. We put two professional bail bondsmen on the committee, including the president of the state association. And we asked them to take a look at what we're doing in this state with regard to pretrial release and make recommendations to the court. Are we following the rules? And if not, how are we not doing it? Do we need to conform the behavior to the rules, or do we need to change our rules? We found out that a number of our courts around the state had created fixed bond schedules. You get charged with armed robbery, your money bond is X amount, regardless of individual flight risk. You get charged with shoplifting, your bond is Y amount, without regard to individual flight risk. We found out that we had large numbers of people in jail awaiting trial, presumed innocent, not because they were high risk, not because they were dangerous or flight risk, but simply because they didn't have money to pay the bail. And our committee made a number of recommendations. In the course of doing this study, I ended up having communications with a number of people around the country who were dealing with this issue. And this is how I came to realize that my opposition to the preventive detention system in the District of Columbia was just wrong. Because what we learned is that so long as judges don't have the honest option of denying release outright to clearly dangerous defendants, they are going to use the only tool they have in order to prevent the release of those defendants, just as that old saying goes, if the only tool you have is a hammer, every problem looks like a nail. And what we found in New Mexico and elsewhere is that judges were using bond setting as a disguised method of preventive detention, because they, in New Mexico at least, didn't have the honest option of saying, you're too dangerous to release, period. And it was like a drift net, attempting to catch the sharks, and some sharks would get through because they were able to pay for it, or they were able to get one of those 0% down saying, give me a couple of days, you know, I'm just a poor armed robber or burglar, I don't have any money on me now, but give me a couple of days to get it, I'll get it back. Some of the dangerous people got out anyway and committed horrible crimes, and then the community would get outraged, led by the press, castigating the judge, essentially for following his or her oath of office and honoring our state constitutional right of all defendants to be released on bail pre-trial. And it was a terrible situation. We were ending up releasing dangerous people despite the known risks, simply because they could either had money or could get access to it. Their friends on the street, maybe their grandma could mortgage her house, someone like that, and someone else equally situated would not get out. And we ended up with the wrong people getting out, and a lot of the wrong people being held in jail, people who were no risk at all, but whose crime was being poor. And they would lose their jobs, their families would break up, lose their homes. The taxpayers got it in all kinds of ways. They would end up paying unnecessary money to house, feed, clothe, guard, medicate all those inmates who didn't belong in jail in the first place and who might ultimately end up being acquitted at trial or having the charges dismissed. At great expense to the counties and the taxpayers who had to house them. And then there were collateral harms. The studies have shown that the longer you spend in jail pre-trial, the more likely you are to commit a future crime. The more likely you are not to show up in the future. We were creating these problems by incarcerating people unnecessarily. So our committee made some recommendations, and one of the first ones they made was that in New Mexico, we ought to seek an amendment to our absolute right to bail provisions of our Constitution, our state Constitution. As the materials that I've distributed but won't repeat here trace, the New Mexico Constitution, like the constitutions of 47 or 48 states, ended up being based on a Pennsylvania constitutional provision from the late 1600s that provided that, except in capital cases, everyone is entitled to release on bail without regard to individual risk factors and so on. And we learned that in New Jersey, just a couple of years before, a broad coalition there that was joined by Governor Chris Christie on one side of the political spectrum, the ACLU on the other, prosecution, defense interests, the New Jersey Supreme Court, and a number of others had put together a broad coalition to propose a constitutional amendment because their constitution was the same as ours and the same as most states with that absolute right to bail. And they realized, as we came to realize, that we were never going to have meaningful bail reform to keep judges from using money to separate those who should be detained and those who should be released unless there was an honest method for determining individual risk and separating those, and one that was not dependent on money. And so our court unanimously, I serve on a court that is very collegial, and I'm proud of all the members of the court. We were unanimous in our resolve to try to address this situation. And we decided we were going to the legislature and seek a constitutional amendment. Most of our contact with the legislature is over appropriations issues. Occasionally we'll try to get a law change where it deals with the functioning of the court system. As far as what's made criminal, what the penalties are, we stay out of that. We leave that to our colleagues in the legislative branch. But this was central to our core mission of doing justice. We needed this tool to be able to deal with pretrial release issues. And so we decided to go to the legislature. But we learned from the New Jersey experience and others that it was important to have a broad-based coalition. And so we went out. I've done a lot of speaking this last year on the issue. In fact, I'm still doing it because we have not finished the job yet. But in anticipation of the first phase, which was getting a resolution through the legislature to put a provision on this November's election ballot for amending our Constitution, we had to go through the legislature and get both houses of the legislature to vote in favor of putting it on the ballot. And so in the months leading up to the legislative session, we worked with finding the right sponsor, someone who got along with both sides of the aisle, both houses, because our legislature, like most, is involved in politics. That's their job. And we went around meeting with various groups. We got the support of the State District Attorneys Association unanimously. We got the support of the Criminal Defense Lawyers Association. They were in it for different reasons. The District Attorneys Association liked the part of our proposal, which was modeled on the New Jersey and federal and D.C. Provisions, saying that if there's a hearing and a judge finds by clear and convincing evidence that a person would be a danger if released or would be an unreasonable flight risk, then a judge might detain them pending trial. We also put in our proposed constitutional amendment something that is not in any other constitution, but is in a statute in U.S. law, D.C. law, Massachusetts law, maybe some others, that nobody should be held simply because of inability to meet a financial condition. That is, if they're not a risk, they're not a danger, they shouldn't be held just simply because they don't have money. And we put it in the proposed constitutional language. So the purpose of the amendment was to make money not be the determining factor whether someone is detained or released pending trial. One aspect of that is that dangerous people, no matter how much money they can come up with, would not be released. The other aspect was that non-high-risk people would not be detained no matter how poor they were. The district attorneys liked the detention for dangerous more, but they realized the other part was fair. The defense lawyers liked you don't hold somebody for being poor more, but they realized detaining dangerous people was fair. We got the backing of the Chamber of Commerce. They were concerned about all these tax dollars. The Association of Counties of the state unanimously supported us. This was after numbers of meetings with each interest group. The faith communities, the Catholic Bishops Organization, the Lutheran Ministry. There were so many organizations that after a chance to study this and think about it and overcome past impressions and hunches that our society has had, that somehow whether you stay in jail or not ought to depend on whether you come up with money to buy your way out. All of them, once they studied it, realized, oh yeah, that doesn't make sense. Oh yeah, we ought to keep dangerous people in jail. Oh yeah, you shouldn't be in jail just because you're poor. And we went before the legislature, which met this January, with a kind of coalition that's never been seen before with regard to any legislation that's come up. The legislators kept remarking about that. Despite that, we almost didn't get it through because there was a group that was opposed to us. And I don't want to denigrate anybody for trying to make a living and make money out of something that's lawful, but there's this industry that has grown up that makes a profit out of the money for freedom system, the commercial bonding industry. And they were out in force because they saw this a threat to their income stream, understandably, and fought us every step of the way in the legislature and before. They tried meeting with the various interest groups that we met with before the legislative session, but in the debates we had, they lost every one of them. We got the support of all those interest groups. Before the legislature, they came in with 5 full-time lobbyists for the legislative session, an army of bail bondsmen working the hallways of the legislature. They contributed money all over the place, and they almost got us stopped up there. One of the things that loosened the clog, where they had the bill stopped at one point, was a blistering editorial in the state's major newspaper. It didn't come about by accident. The particular editorial, it was not something that I had anything to do with, but I had met with the editorial board of that newspaper numerous times over the course of the months leading to the legislative session, sharing all the information that we had, educating the press. I went to bench bar media committee meetings, talking to the broadcast media. They were a little more difficult, but the press still has some journalists who actually study things and are educable. Is this on TV? I mean, you know, bless their hearts. It was a little harder with the rip and read media, but the print journalists still have some of those folks who actually study issues and write on them. And by the time the session came, the editorials in the state's major newspapers were coming out in favor of this because they understood it. And when they saw the bill being stopped by the bail bondsmen in the legislature, they just unloaded. And I sort of referred to it among friends as like a journalistic enema. The blockage was just blasted out within less than 24 hours. One of the bail bondsmen came up to me on the Tuesday evening after they had gotten the Speaker of the House to triple committee referral the bill, which was a kiss of death in a 30-day session such as we had, and to get one of those 3 committee chairs to say it was not even going to be called up for hearing unless we agreed to amendments that the bail bondsman wanted, which would, of course, gutted and killed what we were doing. And all of that came out in the editorial. The very next morning, the bondsman's lobbyists came up to us and said, "We got you boxed in now," smiling. The next morning, that editorial came out, not only pointing out how unreasonable this was, not to let this be heard on the merits, but how the Speaker of the House and the committee chair involved had gotten so many $1,000s apiece in contributions from the bail bondsman during that session, and it just blew everything loose. And we ended up getting unanimous passage in both houses. Nobody voted against it after that editorial came out. And so I think it, for those of you who are working elsewhere, it was an example of how getting a broad coalition of the various interest groups that have influence in the legislature and the media, if you can, with you if you need to do something like this. And I think getting this constitutional amendment is one of the more important reforms. It's not the only one, and I hope to cover a few of the others before I finish my 30 minutes and sit down and get out of here. But it is now on the ballot for passage by the voters in November, and still the only group actively opposing it. They've been quiet lately, although I expect to see them on TV and in October or so before the November election, is the commercial bonding interest. In New Jersey, the only groups to oppose the amendment unsuccessfully were the commercial bonding interests and the criminal defense lawyers. In New Mexico, we have only the commercial bond interests opposing it. So I'm cautiously optimistic that we're going to be able to do that. We're not waiting for that constitutional amendment to pass, to act in other ways, because there are a lot of things we can do with our court rules. Beef up the provisions on the presumption of releasability on non-financial conditions. Have better mechanisms for letting a judge assess that from the moment of the first bond setting, not even waiting until a review hearing takes place later on. And the use of risk assessment instruments. Our committee and the court are working together on proposals to do all that, which doesn't depend on the passage of this constitutional amendment. We're now doing a pilot project in this county, which is the most populous county of the state, in using a validated risk assessment tool. The particular one we're experimenting with is one that was developed in Kentucky. We're also looking at some others that have been developed by other organizations around the country, which take 5 to 7 factors about an offender's history, a defendant's history, that have been proven to be of predictive value in either recidivism or flight risk, and almost like a little mathematical program. We don't want to use it as a substitute for judicial discretion, but to help guide it, and maybe for lower level offenses, provide a system of release on non-monetary conditions by detention centers and so on, who can use this risk assessment instrument to release people before they even see a judge and replace those jailhouse bonds, which are irrational in making money the difference between release and detention. So we're working on that in this county to be a pilot project for statewide application. And one other bill we got through the legislature this term was a bill to provide funding for the Department of Public Safety, the state police, which partnered with us on this, to give them an appropriation to create and staff a 24-hour, 7-day-a-week offender database information center that would gather information nationally and locally about anyone who was arrested, even before they came to see the judge. Someone is booked into the jail at 2 a.m., the detention center, who may have authority to release on one of these quick release systems using the risk assessment instruments could contact by computer or phone the central depository in New Mexico, which brings information from NCIC and so many other sources that aren't normally available to the detention centers or to the judges, and provide information that will help apply this risk assessment instrument and determine whether someone is a high-risk person who needs to be brought before a judge or can be just released with a summons to appear in court. And so that is underway. That is being set up now. The funding will kick in July 1st, the beginning of the fiscal year. And so by the end of the year, we hope to have that in use regardless of what we do, what the voters do with the constitutional amendment. We're also working on proposed rules to flesh out the constitutional amendment. The language of it is on page, I think it's 13 of your materials, but I've reproduced the language of the amendment. It did get amended some during the legislative process. There's some inartful language in there. If something sounds stupid, I didn't write it. I've written stupid things before, but not that stupid language. And but basically it provides that if a defendant in a felony case, that got narrowed during the legislative process, it only applies to felony cases on the detention provision. Our original court proposal hadn't limited that much. But if a defendant in a felony case is found by clear and convincing evidence to be an unreasonable danger if released, the judge can deny bond. We'd originally had unreasonable flight risk also as grounds for detention. The flight risk actually survived by being tacked onto the second part as a result of some unsuccessful maneuvering by the bail bond industry to eliminate it entirely. And so it's now in the bottom part, which deals with nobody's going to be kept in jail just for being unable to come up with money. And the way that second part now reads is that nobody can be held, nobody who's not detainable for dangerousness, relating back to the first provision, or who would be an unreasonable flight risk in the absence of a money bond, shall be held simply for inability to meet a financial condition. So it's sort of a modified detention provision. For dangerousness, you can say you're not getting out. For flight risk, the judge can say, if it's proven, the judge can say, I'm going to set this bond because I think you'll be a flight risk if you don't post this amount of bond, even if that amount keeps you in jail. It's a strange, kind of a strange procedure, but that was what resulted from the bail bondsman's efforts to try to get flight risk out entirely. I think we can live with it. It's certainly going to be an improvement over the current system that we have here in our state. We look at experience elsewhere. I think D.C., if any of you haven't looked at what they're doing with regard to pretrial release, I think it's very instructive. It was educational to me because I'd been out of touch with what was happening in D.C. Since all those years ago when I had my first years of practice there. And after we published the State versus Brown bail opinion that was a result of that bail appeal before us, where we traced how we got our money for freedom system through tribal practices before the Norman Conquest. Take a look at the opinion or the materials and you'll see that interesting way this money for freedom system developed, although the commercial system, as I said, is unique to the United States and the Philippines. It's considered against public policy and all the other common law countries of the world. But we studied what D.C. was doing. I got a call right after I published. I was the author on that opinion, and right after it was released, I got a call out of the blue from a judge who identified himself as a judge on the D.C. Superior Court. Some of you may know him, Truman Morrison, who's been very active in pretrial justice reform. And he wanted to talk about the opinion. He said some very nice things. And we started talking. We developed a constant communication over the last year. And I talked about how we were trying to change things here. He said, you're never going to get anything changed until you have an honest preventive detention system. And he told me about the experience they'd had there. D.C. had that preventive detention system in place since 1970, the one that I'd once been against. But he said when he came on the court sometime after that, the judges were lapsing back into the old practices of setting money bonds, just almost like instinct, not even as finely developed as instinct, just sort of hunch, just picking figures out of the air as these cases come along. Any of you who have been in criminal courts have seen it. And the money system was still there, despite that, and the prosecutors didn't bother going through these hearings. There were too much trouble. Judge, this is an armed robbery case. It ought to be a $50,000 bond. Judge says, yeah, that's right, $50,000 bond. And the defense attorney would say, well, Your Honor, can't we make it $25,000? And they would argue about the amount, not about the concept. He said it wasn't until the D.C. Council passed a law that provided that no one could be held for inability to meet a financial condition, that the judges said, oh, well, what are we going to do with these dangerous people? Oh, yeah, we have this preventive detention thing. And so they started using that in the 90s. And if they were dangerous or a high flight risk, they would deny bond. And for the others, they would release them without financial conditions. In D.C. now, as a result of that, there is no person who is sitting in the D.C. jail tonight awaiting trial simply because they can't afford the bond. There are some sitting in jail. They're the 15% who are considered too high risk to release. All the rest of them are released on non-financial conditions. It is a much lower detention rate than we have here in New Mexico. I think we're holding 35–40% of our people pretrial, most of them simply because they don't have the money. And that's why I started this out by saying I realized I was wrong, because that detention statute that I opposed back in D.C. is now resulting in a much better pretrial justice system than anything we have here, regardless of our constitutional right that everybody gets released on bond. So if there is any one thing I can tell you that we've learned here, it is that sometimes in order to protect the rights of a majority, you have to tailor some adjustment to the rights of the ones who are causing the system to fail to do justice. And